Okay, let's get started. Hello everybody, this is Randy Hughes, Mr. Land Trust, and we're going to get our call started here right away. Let me just take care of a couple of things and then I'll start the recording. As I always say, if you would please mute your line by hitting *6, we will have a clear line for everybody to enjoy tonight's call. Then if you have a question, hit *6 again and it will unmute you and you can ask your question. If you've not already emailed your questions in, feel free to do that now. And you can send that to me. That's randy@mrlandtrust.net. So feel free to ask questions either related to other people's questions or totally different. These calls are for you, the Land Trust University members. So tonight is the night to ask your questions for this month. I did post last month's question on the Land Trust University URL for those of you who might have missed the call or just liked it so much you want to listen to it again. And as a reminder, all the calls for the last 7 years are posted on the Land Trust University website for you to enjoy. And we went to a great deal of trouble to list those by subject matter, so you can easily go through and see what the subject of the call is and decide which call you want to listen to again over the last 7 years. All right, now let me get the call started to be recorded. Can everybody hear me all right?
Yes.
Okay, thank you.
This conference is being recorded.
Okay. We're doing something a little bit different tonight in that we're actually doing two things different tonight. One is we're having an evening call, and all the last 7 years' calls have been daytime calls at 11 o'clock Central Time on a Saturday morning. But because some of the Land Trust University members had said that that wasn't exactly convenient for them, they had things to do on Saturday morning, they asked if we could try an evening call. And so that's why we're doing this tonight, is to see how popular an evening call might be. The second new thing we're doing is we are broadcasting this call live on Periscope. And for those of you who are not familiar with Periscope, it's a method of broadcasting live all over the planet. And it's recorded and can be watched later, I think up to 24 hours afterwards. And this broadcast is being sent out to anybody and everybody, not just Land Trust University members. So it's a way to let people know kind of what the Land Trust University is all about, what the benefits are, and for them to get a little taste of these calls and see if they might have an interest in joining in the future. So I want to get started by telling you that on today's call we're going to discuss many questions that have been emailed in already, and your live asked questions, and any questions that come in via Periscope, because they have the ability to ask questions. They can't talk to us, but they can ask us questions, and so we'll try to get to those as well. I have my marketing director in the room with me, Andrew, and he's going to read those questions off the screen from Periscope viewers as we go along. So we'll banter back and forth. I do want to mention that my May newsletter, which is another benefit of belonging to the Land Trust University, my May newsletter was sent out last week. So if you did not receive a copy of that, I'd be glad to forward it to you. Just shoot me an email, randy@mrlandtrust.net. But you should have received that last week.
Randy, we had someone who just said they just joined. What's the subject of the Periscope?
The subject matter is the Land Trust University members' questions. So these are people who have purchased my home study course, have studied it, are setting up their own land trust to hold title to their investment property, and have questions about land trusts, LLCs, personal property trusts, and other issues that we discuss on this call. I do want to also say, before we get into these questions, that we've been doing, as many of you know, we've been doing the Periscope broadcasts with my attorney friend Linda Sands out of San Diego, California. And the next one, I believe, is next Tuesday night, that we're going to do a follow-up. We're doing one a month where we're going through the trust agreement paragraph by paragraph and breaking it down, explaining what each paragraph means. So that's another free benefit, and I encourage you to follow me on Periscope to get these benefits, and you can do that by following me at Mr. Land Trust. That's MR Land Trust on Periscope. All right. Before I start reading questions that have been emailed in, does anybody have a hot burning question on the call that they want to jump in and ask right away? If you do, hit *6 now. And yes, the answer to that question, I just got an email saying, am I able to take email questions? And yes, I can take email questions. So if you want to email some in, I will check my email once in a while and answer those questions that come in tonight via email. The ones I'm reading from my computer right now have been emailed in over the last 3 or 4 weeks since our last call. So, hearing no live questions at the moment, let's jump right into some of the emailed in questions. This student says, he's given me a couple of scenarios. Scenario 1, the property being sold outright for cash and currently held in a single member LLC. There is currently a private investor lien note on the property. Do you think it's necessary to put property in a land trust, or should the property be kept in the LLC and just transfer the membership to the new owners? Well, if you're selling for all cash, there's no need to keep either a land trust or an LLC intact, in my opinion, unless for some reason they want that entity, but they could certainly create their own. If you're selling for all cash, just deed out of the LLC directly to the buyer, give them a deed, and let them go on down the road. I don't think an entity is necessary in that example. But if you're not selling for cash, in other words, you're providing seller financing, you could do 2 things. You can sell the LLC membership on an installment contract, and that's assuming you don't have other assets in the LLC. Obviously, if you've got 5 properties in one LLC, you don't want to sell the membership to somebody for one property because they'll get an interest in all 5 properties. So if you've got one LLC with one property in it, yes, you could sell the membership of that LLC on an installment contract basis. If you have other assets in the LLC, then I would suggest you deed the property out of the LLC to a land trust and then sell the beneficial interest in the land trust on an installment contract. And what we mean by that, by an installment contract, is that the buyer is not paying all cash. They're giving you a down payment, and they're going to make monthly payments over a period of time, and eventually you're going to give them the deed. You'll probably amortize that loan like a bank would over, say, 25 or 30 years, but you don't want to be stuck in this deal for 25 or 30 years, so you'll have what's called a balloon payment, which means that in 3 to 5 years or whatever you negotiate with the buyer, they're going to have to go out and get their own financing and pay you off so you can cash out of this deal and not have to wait 25 years for your money. So those are scenarios for where you're providing financing, but the initial question was just a cash deal, and a cash deal, just all you need to do is deed out of the LLC and get your cash and run. Okay, his second scenario is the property being sold is medium term, between 1 and 5 years. Owner is financing with no current lien on the property. Well, my first reaction to that is I assume he means he's the buyer of this property. The owner's financing it for him. The owner doesn't have a lien on it, but the owner's going to sell it to him and finance it for him. So if that's the case, he's the buyer, then if so, I would still put the property into a land trust to protect that property from liens and judgments against everybody involved. What's dangerous about buying property on a contract is that if the seller has a lien or judgment rendered against them, or say they get divorced and things get messy and the ex wants a piece of the property or whatever, or wants to put a lien in it, it's just so much cleaner to put the property into a land trust and then buy the beneficial interest in the trust. That way, if any liens or judgments are filed against the seller or you as the buyer, they're not going to register against the title of that property. So the land trust is a great tool for seller financing in particular. All right. Any questions?
Randy, we had a question come through chat on Periscope that I didn't quite catch. It had something to do with a header on the land trust agreement. If the person who posted that question could type it into the chat box again, please, so that we can catch it. I'll try to do a better job of reading it.
Yeah. Part of the problem with Periscope is when you type in a question, it just zips right by and it's gone, and you have no more access to it. So if you don't read it fast, it's gone.
So I'll be on the lookout for that, and you keep going.
And that was about a header on a land trust agreement?
Yeah, something like that.
Okay. So if you're still on Periscope and you posted that question, please post it again, and we'll be watching closely to answer that. Any questions from the phone-in audience?
Somebody needs to mute.
Yeah, let me just reiterate, please everybody mute your line by hitting *6 so we don't have to hear the pots and pans in the background. Thank you. All right. We will move on with the emailed in questions. Hi Randy, regarding tonight's call, I have the following questions. When forming a land trust, how does one go about selecting the jurisdiction? I reside and do business in California. How do I determine the best option? Well, my first suggestion is if you're just learning how to do these land trusts, and you're in a state like California, you might want to just form a California land trust, just to get one under your belt and get the experience of it. Because some of the advanced techniques that I teach can get a little difficult to explain to somebody if you have to explain it to a title agent or an attorney or something, and I'd rather you have some confidence build up before you do that. But in answer to the question, how do you select a jurisdiction? Well, I personally don't like using a jurisdiction in which my rental property is in. So no matter where my rental property was, I would select a jurisdiction away from, out of state from that property. As most of you know, I like Virginia land trust law. I also like the method of using Ron Allen, the American Native Indian attorney that we use out of Virginia, for using Native American business entities as trustees or as LLC beneficiaries, and then that's not state specific. But if we're talking state specific, and while we're on that subject, there's no federal land trust law, it's all state by state, and there are only 6 or 7 states that actually have a land trust statute. Although no state, to my knowledge, has outlawed the use of a land trust, it's my suggestion that you use one of the states that actually has a land trust statute when you form your land trust agreements. So let's take an example here. If I lived in California and all my investment properties in California, I'd probably form Virginia land trust agreements, one trust agreement for each property, and title those California properties in Virginia land trusts. Why? Well, I explain it in detail in my basic home study course, so if you want a detailed answer, look there. But the short answer is some states require duties of the trustee to make the trust valid. And I don't want my trustee to have any duties other than to hold title to the property and deed it out when I tell them to, or sign a mortgage when I tell them to. Other than that, I don't want my trustee to be responsible for insuring the property, collecting rents, any sort of management duties, nothing. I just want them to hold title. I don't want them to touch any money. So that's the way you determine the best option, is how you go with your philosophy there. Now, it's also my suggestion that if you're going to use out-of-state trust, you should have an out-of-state trustee. So if you have a Virginia trust, then you should have a Virginia trustee. If you have a Florida trust, you should have a Florida trustee. That helps set the nexus for the administration of the trust and helps set jurisdiction in case any litigation occurs regarding that trust. This person goes on to say, what are the pros and cons of a California land trust versus a Virginia land trust? Well, I think I've answered some of that already. As far as duties of the trustee and using an out-of-state trust. Now, to sue a land trust, you have to initiate the lawsuit by serving the trustee. And that's another reason why we like to use out-of-state trusts with out-of-state trustees, because they're obviously more difficult to serve and more expensive to serve. And let's stop right now and just explain that we're not trying to avoid our just responsibilities in life and take advantage of people, but we are trying to avoid being taken advantage of by frivolous lawsuits. And the way our legal system is going in America, it behooves you to protect yourself against frivolous lawsuits because they're expensive and time-consuming and very, very aggravating, and you lose a lot of sleep over them. So anytime you can avoid a frivolous lawsuit, you've done yourself a favor. His last question is, can you please clarify what is the exculpatory language you use anytime you have a trustee sign anything? In my basic course, I have what's called exculpatory language, and I've reduced it to a rubber stamp. And you too can go to your rubber stamp store or order it online and have that language put in a rubber stamp. And every time your trustee signs any document, you stamp underneath their signature this exculpatory language, which means they're signing only as trustee, not personally as an individual. So you always want to protect your trustee, even though there are 100 years of case law in Illinois and Florida that back up this situation about liability of a trustee. It's still always a good idea to make it clear by either rubber stamping that language, or you can just print it out from the form section of my course material and staple it to any document that your trustee signs. Either or is just as good, and then underneath the trustee's signature you'd say, "See attached," and that would do the trick. So that is the issue on exculpatory language. Andrew, did the person come back with their question?
They did. It had to do with header for the county and state on the the trust deed versus something to do with the state. I didn't quite absorb it all, and I've gotten myself a little bit better prepared. But does that give you any idea of what he's asking about?
About what kind of a header to put on the deed and trust?
It does have to do with the deed and trust, yes.
Okay. Well, number one, if you're still on the broadcast, we understand now you want to talk about a deed and trust. And so if you can ask more specifically what it is about that deed and trust you want to know, if it's about the header or the footer or what address to put on there for mailing of the tax bill perhaps, or maybe even what's the difference between a warranty deed and a deed to trustee. I will tell you this, that there's a lot of confusion about a deed to trustee and a trustee's deed. They are two different documents. And a deed to trustee, sometimes called a deed in trust, is the deed you use when you are putting the property, taking it out of the seller's name and putting it into your trust. And which is the best way to do this is to take title directly from the seller to your trust. That's the deed in trust or deed to trustee. Now, somewhere down the road when you want to sell that property and you're going to deed out to a new buyer, that's when you use the trustee's deed. And for all of those who have my home study course, you have samples. I believe I've given you 2 samples of each of those deeds in the forms section of the basic course. I'm going to move on unless you've got something. Okay. Any other questions from the audience on the call tonight? Just hit *6 if you want to ask a question. Sounds like we've got a quiet crowd tonight.
I have one question.
Okay, go ahead.
I'm just beginning, so this is probably a really basic question, but I was on page 31 of your book, and it says when making offers, as noted in the note 4, have an offer for we, your buyer, or assign. And I'm wondering, does this mean you actually put your buyer, or what if his name was Tom? You put Tom buyer or assign?
No, Bill Buyer is just an example of what you would put in there. But let's talk about your subject matter here, and that is how do you make offers when you're using land trusts? There are 2 ways you can do this. One is you can make the offer in the trustee's name, and then close the deal in the trustee's name. The second is you make the offer in your own personal name, and then when it comes to the closing date and the seller's attorney or title company or closing agent asks, how do you want the deed to read, then you would give them the trustee's name and the name of your trust. So you would take title directly into your trust that way. I used to make the offers in the trustee's name, but it from a practical standpoint, it became rather cumbersome because I would often spend 2 or 3 days negotiating with the seller face to face with my name, and then I bring him a written offer that's in somebody else's name, and that would spook some people. And so I went back to just making the offers in my name, which was consistent with the negotiation process. And then by the time we get to the closing table and they ask how I want the deed to read, then I give them the name of the trustee and the trust. And by that time it doesn't matter to the seller. In fact, they don't even know that there's a different name on the deed until the closing table. And oftentimes they don't even see it at that point. So it's not a big deal to them. They're getting their money. They're going to sign the title over to whomever we tell them to because we're giving them the money. But those are the 2 ways you can do it. Now, in Illinois, where we live right now, contracts are assignable unless you state in the contract that they're not assignable. And I know in some other states that's not the case, that you do have to actually put Randy Hughes, buyer, or his assigns to make the contract assignable. We don't have to do that in Illinois, but each state is different. So did I answer your question, ma'am?
Not really sure. You're saying you don't really do this then? I guess I got lost. Don't put Bill Meyer to do at the very end, not when you're making the offer.
I'm sorry, I did not understand you or hear you properly. Could you say that again?
So when we're making the offer, you don't put Bill Meyer or his assign?
No, the buyer's name would either be you as the buyer or your trustee as the buyer.
Okay, I see.
Yeah.
Oh, I understand.
Yeah,
Okay.
Bill Buyer was just an example of a name to use.
I see. Thank you so much.
You're welcome. Okay, anybody else have a question before we move on? Hit *6 now. All right, let me continue on with this emailed in question. If you set up a land trust with two beneficiaries, each having a 50% beneficial interest, you mentioned that this arrangement might be construed as a general partnership, and therefore subject the beneficiaries to unlimited liability. Is that correct? Well, yes, it is correct. There are court cases that have found in the past that co-beneficiaries to a land trust were like general partners. And general partners have liability for the actions of their partners. And you don't want to be a general partner with anybody on the planet, even your spouse, because that kind of liability is just it's something you don't need that can destroy you without you actually doing anything yourself. The other person can destroy you. So it goes on to say, so how does having two personal property trusts, each having a 50-50 beneficial interest, solve the problem? So my suggestion in the course material is, instead of you and your co-investor being co-beneficiaries in your names of the land trust, each of you set up a personal property trust, which is easy and has no cost to it, and be the beneficiaries of those personal property trusts. Then have the personal property trust be the co-beneficiaries to the land trust. So you'd have a land trust with beneficiaries as other trusts, so the unlimited liability, that general partnership status, would be between two trusts that have no other assets in them other than the beneficial interest, those 50% beneficial interests. That way, if something goes haywire, the most you've got to lose here is the 50% interest in the land trust, not all your other assets, because you entered into it on a personal basis. That's why I suggest you do it that way. That's how it solves the problem. Okay, the last part of this person's question is, can a beneficiary also be a trustee? Is there ever a time when this might be a good idea? Well, I don't think so. I don't think it's ever a good idea. Remember, the main reason why you want to have a trustee is, and put it in trust, is so it's not in your name. The property's not in your name. All the states that I'm aware of, except Florida, have a law in the books that's called a merging of interest. And it's a theory under the law which says that if you're the trustee and you're the beneficiary, then you are all parties to this contract, and you can't have a contract with yourself. So you don't have a contract. So you don't have a trust, and basically you've done all this for nothing. So you shouldn't be the trustee and the beneficiary for that reason, and you shouldn't be the trustee and the beneficiary for the reason I stated about privacy of ownership. In the state of Florida, they did pass a law about 3 years ago that said that there is no merging of interests and that you can be the trustee and the beneficiary. Why you'd want to be, I don't know, but they did it, and so you can do that down in Florida if you're so inclined. All right. Any other questions before I move on? No repost on the, okay. All right, next question is, I haven't gone through the entire course contents as of yet, just finished DVD 1 and 2, so forgive me if this topic is covered in depth, but when you take a property subject to, excuse me, if you'd please hit *6, so we don't hear the noise in the background, we'd all greatly appreciate it, because we are getting some feedback. Thank you. When you take a property subject to the existing mortgage as an investment strategy, how do you deal with the escrow, which is generally held by a bank? My best guess is to appoint the seller, trustee, and beneficiary, fax the paperwork to the bank to let them know it is in a trust, and then have the seller assign the trustee and the beneficiary over to me. And then I can anonymously appoint another party as trustee. But won't the banks know that a new person would be insured as trustee? I did a land trust deal once with Bank of America, and they sent me a due on sale clause violation because they picked up on the fact that the seller was not the trustee. Okay, so we're talking about buying property subject to the existing loan. And number one, no, I don't do this in escrow at a bank. I do my closings with my attorney and the seller's attorney, if they have one, at either the seller's attorney's office or my attorney's office. And we sit down and go through all the paperwork and we sign it. We deed the property from the seller into a land trust. Then the seller assigns the beneficial interest to me if he's providing financing. Now, sometimes I'll just write him a check for enough to get him out of the house, and I take the assignment of the beneficial interest. Or if he's providing long-term financing for me, where I give him a down payment and make monthly payments, then he assigns that beneficial interest, but I don't get the original. I get a copy, and our contract and the assignment of beneficial interest are held in the escrow, preferably at my attorney's office. So when I make my last payment to the seller, I don't have to chase him down and figure out where he's at. I just have to prove to my attorney, here's my last payment, and give me the assignment of beneficial interest. Now, one good technique that she's kind of brushed onto here is to, if you're worried about the lender catching wind of the property being put into trust, which there's nothing wrong with that. If it's their personal residence, they have a federal right to put their property into trust and not trigger the due on sale. That's assuming that they put it in trust and they are the beneficiary. So one technique is to put it into a trust and call the trust. Let's say the seller's name is Miller. You could call it the Miller Family Trust. And Jim Miller, the seller, you can make him the trustee. And you could make he and his wife or whoever on the title as beneficiaries, and then make it an immediate assignment to you as the buyer. Then you don't have that merging of interest issue because you have two different people. You have the seller as the trustee and you as the beneficiary. So then if you are sending in a new insurance certificate, which I think what she's alluding to here is that the insurance may trigger the lender to call the due on sale clause. Then when the lender sees that Miller Family Trust and Jim Miller as trustee, they'll know and assume that the property was put into a trust for estate planning purposes, and they won't call the loan due. So there are several techniques kind of wrapped up into one answer there. But bottom line is no, you're not going to have an escrow closing. You're not going to have a bank closing. It's going to be a private closing at your attorney's office, preferably, to get everything signed and then held by your attorney for final payoff. Okay, any other questions before we move on? If you're on the call, hit *6 to unmute yourself. If you're on Periscope, you tap, I think, in the lower left-hand corner, and it brings up a screen that you can type on somewhere on the bottom there. Okay, go right ahead, ma'am.
So if you have the seller that's offering the financing on the subject to, what's the worst thing that can happen if they're the trustee and you have 100% beneficial interest?
Well, if you have 100% beneficial interest, you have control over the trustee. They can't do anything about your written direction. Now, from a practical standpoint, what I would do is, as soon as I became the full 100% beneficiary, I would fire the seller as trustee and hire somebody that I wanted to be trustee anyway. And you can do that very easily. And one of the forms you got from me is an appointment of a new trustee. And you can hire and fire your trustees all day long very easily. And you don't even technically have to notify the old trustee that they've been fired when you hire a new trustee. So it works very, very smoothly, and you as a beneficiary have the power to control the trustee and everything they do. Okay?
Okay.
All right, here are some more questions that came in.
That's assuming you retain power of direction.
Well, okay, let's cover that. Good point. That's assuming you retain the power of direction. When you form a land trust, most people will make the beneficiary also have the power of direction, which means the power of direction is the ability to tell the trustee what to do. So generally, most of the time, the beneficiary has the power to tell the trustee what to do, but it doesn't have to be that way. Let's take an example. Let's say that I have an adult disabled child, mentally disabled child, that can never make financial decisions for herself, and I want to provide some income for her. So I put this piece of real estate into a land trust that generates rental income and make her, my adult, mentally challenged child, the beneficiary. That means all the money, all the rent income flows through to her to help support her. But because she can't make decisions, business decisions, I could retain the power of direction over the trustee and the trust, which means that at any point in time I can change this deal and tell the trustee to deed the property out of the trust or to sell the property out of the trust or whatever I want to do. So I retain the control, but I don't get the money. And that is the difference. So, as long as you have the power of direction and the beneficial interest, then you are in control of 100% of each land trust you create. I've written quite a bit about the power of direction, and I think you'd find it fascinating, some of the creative things you can do with the power of direction. If you'd like one or more of my articles on that, send me an email, and I'd be glad to send it to you. Question came in and says, can I, as a foreigner, get a land trust? The answer is yes. Do I have to have a Social Security number? The answer is no. Can I have a trust together with a business partner? Well, yeah, you can, but it kind of goes back to that question that was asked earlier about co-beneficiaries. You can be co-beneficiaries, but I wouldn't suggest it. I like the two other trusts, personal property trusts, or it could be two LLCs. It could be co-beneficiaries, but just be careful that there aren't other assets in those LLCs that might be at risk. What do I do in the case of joint ventures in respect to land trusts? I don't understand that question, so if you could please re-email to me, clarify, because I don't understand what you mean by what do I do in case of joint ventures in respect to land trusts. Sorry, just can't figure that one out. Okay. Any questions? On the call? Anybody want to ask a question? It's *6, and that will unmute you. All right, then. We've got some more questions coming in. Yes, go ahead, ma'am.
When you were talking about the Miller Trust, for the do on sell clause,
Yes.
and you had the husband as the trustee, the wife as the beneficiary, and then I couldn't get the last part. Then she assigns her interest to me for the beneficiary, or?
Were we talking about the seller financing?
The due on sale.
Well, just after that, when you're trying to avoid the do on sell clause,
Yes.
and then you said some of the family is named Miller, and you put the trust in the seller's name, like Miller Family Trust,
Yes.
and you said the husband would be the trustee and the wife would be the beneficiary.
Well, the husband and wife. It depends on who's entitled right now. If the husband and wife are say tenants in common on a deed, and they deed out to a trust, then you'll probably make them co-beneficiaries of the land trust, and one of them, or both of them, could be the trustee. You see, you can have more than one trustee. You can have a board of trustees if you want to. But in this example, it would you could just say the husband's a trustee and the husband and wife are beneficiaries.
Okay, but it was actually the part after that. I thought you said that she or they would assign something to me. Was it being the beneficiary?
Yes, they would assign their beneficial interest to me as the buyer. And what that does is it does a couple of things. If I'm a cash buyer, then I have total control over the trust and I can do whatever I want to immediately. If I'm a contract buyer, then I don't have the right to do anything other than pay off the contract and then get the beneficial interest, and then I'm in control. So, but from a tax standpoint, even if I'm a contract buyer of a beneficial interest, I can still deduct the taxes and the interest paid on that contract. Okay? So isn't that interesting that you don't own the property? Technically you don't own it, but you can still write it off.
Okay. But they assign it to me right away, like when we're setting up the trust, right?
Well, they would sign the assignment form, but it would be held in escrow until you paid them in full. You know, it's kind of like, you know, if you go out and buy a truck and finance it at the bank,
Right.
and they hold the title to the truck until you make 5 years worth of payments.
Okay, I see.
You see what I mean? If you make 4 years and 11 months worth of payments and default on that last payment, they're not going to give you the title, are they?
No, okay, I see what you mean.
Yeah. Okay, good deal. All right.
Hello, Randy.
Yes.
This is Ron Allen. How are you?
Hi, Ron. How's that new grandchild?
Oh, he is growing like a weed. I had one comment on the case of joint beneficiary.
Of what, Ron?
I have a comment on in the event of a joint beneficiary where they have 50-50.
Okay.
You know,
Yes.
in a case of husband and wife, there's a thing where you can say, you know, husband and wife, last name, comma, by tenant, and there's some other legal phraseology in there, and then they have their successor beneficiaries as their children. So the way this works is, should one spouse pass away, the other spouse still retains 100% of the beneficial interest. But should both spouses pass away, then of course the successor children will become owners of beneficial interest. So that was I thought was a unique setup. Let me a couple of dispute clients that I have.
Well, I think, aren't you talking about joint tenancy with the right of survivorship?
Yes, sir.
Okay. Yeah, you can designate the beneficiaries of a land trust as that. So you can name two beneficiaries, co-beneficiaries, as joint tenants with the right of survivorship. And then if one of them dies, the other one is automatically 100% owner. And then if that person dies, it goes to the successor beneficiary, right?
Yes, sir.
Okay, right. And that's for married folks, and I don't know why anybody else couldn't do it also, and set themselves up as joint tenants. Are you aware of any reason why they couldn't do it even if you're not married?
No, but that brings us to some peculiar in modern society.
Yeah.
I haven't had to go there yet.
Yeah, I understand. Well, thank you for interjecting that.
All right, sir. Thank you.
Yeah. Okay, another question just came in. I'm new and wondered about when making offers, as noted on page 31 of the offer form. Oh, okay, that one we already addressed. Sorry. Let's go on to another one.
Randy, somebody who has followed a lot of your periscopes, Andy Gomez, has just joined us. So,
hi, Andy. Thanks for joining us. Appreciate you being with us tonight. Hi, Randy. My brother and I currently own a property jointly. Want to transfer the title to a land trust. However, we do not want to be co-beneficiaries. Can you explain step by step how do we form a land trust to transfer the property into it in conjunction with personal property trusts and perhaps an LLC for asset protection? Okay. Step one, you can form two personal property trusts. You form yours, your brother forms his. Now, those personal property trusts are going to have trustees, and you guys are going to be the beneficiaries.
What are you doing, lady?
Okay?
What do you want? I'm listening to a phone call.
Okay. Let's see. Hold on a second. Okay, sorry, we were getting some feedback there that I had to mute those folks myself. So, each brother forms their own personal property trust with a trustee at the head of the trust. Then you form your land trust. You transfer the deed into the land trust, and the trust agreement that's receiving that deed is going to designate two beneficiaries. And those beneficiaries are going to be the trustees of the personal property trusts. So instead of you and your brother being named as co-beneficiaries, the trustees of your personal property trusts will be named as the co-beneficiaries of the land trust.
Ad eviction asks the creator. I'm not quite sure I understand what he's asking.
If you could clarify that question on Periscope, please. We don't quite understand.
Grantor. It says ad eviction grantor.
At eviction?
That's his name,
Oh,
that's his
okay.
handle.
I don't know what the question is. Does he want to know who the grantor is?
He
or-
needs to, please write out the full question at eviction.
So I'm hoping I answered that question. Now, they did say, and perhaps an LLC for asset protection. Well, you could make the beneficiary of your personal property trust. Each of you could have your own LLCs as the beneficiary of those personal property trusts, which is probably a good idea, because remember this, just because you put your property into a land trust doesn't mean there's no more liability on the property held in the trust. That property liability flows through to the beneficiary. So whoever the beneficiary is gets the liability. And that's why most real estate investors make the beneficiary to their land trust an LLC or a corporation or another trust.
At eviction writes, who is the grantor/creator?
Of the land trust or the personal property trust?
Why don't you answer both?
Okay. Well, the grantor on the land trust will be the seller of the property who's deeding into the trust. The grantor on the personal property trust will be those brothers. The beneficiaries will be the grantors on the personal property
On
trust
each of their own.
each of their own personal property trust agreements. And just for you folks to know, I provide 2 different personal property trust agreements in my advanced course. One of them is a real simple one it's designed more for like cars and motorcycles and boats. And one's 7 or 10 pager, a little more involved for maybe these kind of situations. Okay, another question just came in. Which is better to have as beneficiary of a land trust and why? An LLC or a personal property trust? Well, it depends on what kind of a personal property trust, but my short answer would be an LLC. But there are some really terrific personal property trusts out there that are very extensive. Nevada, for example, has a terrific personal property trust. And they have a law out in Nevada that says after 2 years of forming that trust, you can't sue it. Can't even sue it. Now, many other states, Ohio and Alaska and Delaware and several other ones have been competing to steal this business away from Nevada. And in fact, I believe it was Ohio last year passed a law saying that they've got a 1.5 year waiting period.
I thought it was Indiana.
I think Indiana just passed one too to get to 1.5. So they're all kind of one-upping each other to do this. But these are more sophisticated personal property trusts, and they entail a lot more. So you're going to have to get some professional help to set those up. For example, a personal property trust like I'm talking about in Nevada requires that part of the assets in the trust be held in Nevada. It requires that the trustee be a resident of Nevada. So there are some strict requirements to meet there. Unlike the personal property trusts that I provide you in the advanced course material, are just the type that are formed under the laws of the United States of America. They're just general. They really have no asset protection benefit. They're just more for privacy and to separate ownership of assets. So if you've got a snowmobile and a shotgun and a motorcycle and a motorhome and a car and a boat, each one of those should go in a separate personal property trust. So each of your assets are separated from the other. Okay, let me see, because we're getting down to having to talk about a few other things here before we wind up. I think yeah, okay. I think that brings us up to date. Any other questions from our call audience? If so, just hit *6 and that will unmute you. Any other questions from Periscope?
Yes, our viewer who goes by the handle @eviction asks, what about an FLP?
The question is, what about an FLP? So he's talking about a family limited partnership. And those are good in certain situations, and you might want to consider making them the beneficiary to the land trust. Oftentimes those family limited partnerships are recorded with the family name in them, and so you lose a lot of anonymity. So if you have a family limited partnership, consider making the beneficiary of a land trust, because the benefit of these land trusts is they don't cost anything. So you can put each property into its own separate trust, as opposed to dumping 10 properties into a family limited partnership. And then if you got a lawsuit against one property, that could, even if you win the lawsuit, it can tie up all the properties in that partnership for the length of the lawsuit, which could be years. So it just benefits everybody if you put each property into a separate trust. And since it doesn't cost you anything to do it, why not? Okay, I want to mention a couple of things here. I'm going to be in Chicago this Saturday at the Embassy Suites Hotel in Rosemont, Illinois, for the Realty 411 Expo. I'll be speaking there. That's this Saturday, Embassy Suites, Rosemont, Illinois. That's a suburb of Chicago. Then on June 10th, I'll be in Houston, Texas for another Realty 411 Expo at the Houston Marriott Corridor Hotel. On October 6th, I'll be speaking in Oklahoma City that evening to the Oklahoma City Real Estate Investors Club. And then I'm going to be teaching a 2-day class. That's a Thursday when I speak. The following Saturday and Sunday, I'll be teaching a 2-day class with Dennis Henson, who's a really sharp guy out of Dallas, Texas. He's going to teach a day and I'll teach a day. Still in Oklahoma City, but for folks in that area that might want to come visit us, we'd love to see you. That's on October 8th and 9th.
And Dennis is part of the presentation?
Dennis is going to talk on seller financing and private money, I believe. And he's a real sharp guy, very successful in the Dallas area, been in business a long time, so I'd highly recommend you come and listen to him speak as well. So you can check out on my website, which is landtrustmadesimple.com. That's landtrust with an S, madesimple.com. On the left-hand sidebar, there's a link that says Land Trust Calendar. And it's not totally up to date as of this minute, but I'll have it posted a little bit later tonight, this new information. And then you can make arrangements to visit me and attend these events if you'd like to. We'd love to see you. Also, we ask that you follow me on Twitter. I'm at Mr. Land Trust, or LinkedIn by using the phrase Mr. Land Trust, or Facebook. I'm on Facebook at Land Trusts Made Simple. And of course, all you Periscopers know that you can find me on Periscope with the same handle as Twitter, which is at Mr. Land Trust. So mark your calendars now. We will go back to our Saturday morning calls in June. I'll assess what happened tonight on this call and get the feedback from the students and decide if we're going to do any more evening calls. But the next call will be June 18th at 11 a.m. Central Time. And I will have this call that's being recorded. This will be posted on the Land Trust University website by this coming Wednesday evening. So we are right on time. Thank you for attending.
Two more things.
We have two more things, all right.
One is, can you let people know about next Tuesday, May 24th?
Next Tuesday, we'll be doing a Periscope again with Linda Sands, the attorney out of San Diego. And we'll cover another paragraph or two on the trust agreement. So if you want to hear about that, follow me on Periscope.
And if you want to watch the previous two, go to youtube.com and check out Randy Hughes. You'll see the previous two videos, periscopes of your talk with Linda Sands on YouTube.
Yeah, so since Periscope only keeps it up for 24 hours, we have to move the video to YouTube. So if you go to youtube.com, type in Randy Hughes, you'll get those previous 2 Periscope. We've only done 2 other Periscope broadcasts with Linda, and we're going to keep stringing them all together for you. So if you didn't catch those, and then you're up to speed for the one coming Tuesday night.
And lastly, Ad Eviction would like your website address again?
Again, my website address is land, L-A-N-D, trusts, T-R-U-S-T-S, made simple.com. So I look forward to seeing you all in June. Keep those calls and questions coming in, and thank you very much for attending tonight. Good evening, everybody.